Hi, this is Patrick Conroy, and today we're covering Chapter 20, Agency and Liability to Third Parties. So what do we mean by agency? Well, agency is a consensual relationship between a principal and an agent. The agent is authorized to act on behalf of the principal and is subject to the principal's control. So, you might be familiar with people in the entertainment industry having their agents. Talk to my agent. Well, the agent is someone in those situations who could set up interviews with the entertainer, arrange bookings for the entertainer, etc. Or in real estate, we have real estate agents. They act on behalf of the principal in showing your house and things like that. Agency law is primarily state common law, except in Louisiana, where we have statutes that arise in agency situations. The restatement of agency is a valuable reference on agency law. It's sort of, model agency law. But it's really one of those things that comes from the common law that's really been put practice, for ages, even before the founding of the country. Okay. So some terminology. An agent is a party who has the authority to act on behalf of and can bind or act on the part of a principal. So they can contractually bind the principal with somebody else. The principal is the party that an agent's authority can bind for whose behalf an agent can act. So we have the entertainer and they have their agents. The agent can bind them to do a performance. A fiduciary is a person who has a duty to act primarily for another's benefit. An agent is a fiduciary, and we get to fiduciary a little bit later. How do these relationships begin? Well, it could be by expressed authority, formed by making a written or oral agreement. I hire you to be my agent and you can bind me for these things. Implied agency, formed by the implication through the conduct of the parties. Maybe we didn't actually sign anything or express it in detail, but you've been doing my contracts for 5 years, so we still have an understanding that you do that. Agency by estoppel, formed when a principal leads someone to believe another individual is his agent, but the principal has no agreement with the presumed agent. Okay, I own a store, a vendor comes in to try to sell me something, and I say, talk to the manager. So even though I never told the manager that they could be buying things for the store, I have done something that led someone else to believe. Agency by ratification. Okay, that maybe the store manager, the vendor came in and wanted to sell them paper for the Xerox machine. I didn't have the actual authority to buy the paper, but I did anyway. Well, later, the principal might come in and say, hey, that was a great deal. No, you didn't have the authority, but we're going to keep to it. In order to be an agency by ratification, number one, the individual must misrepresent himself or herself as the agent for another party. The principal must accept or ratify the unauthorized act. The principal must have complete knowledge of all the material facts regarding the contract, and they must ratify the entirety of the agent's acts. Not just part of it, the whole thing. Types of agency relationships. Principal-agent relationship. Employer hires employees to enter into contracts on behalf of employer. parties have agreed that agent will have the power to bind principal in contract. So you have a large company, and you have a buyer's agent who you have given the authority to do the buying. Employer-employee relationship. Employer hires the employee to perform certain tasks, and the employer has a right to control the conduct of the employees. Store manager. An employer in an independent contractor relationship. Employer hires persons other than the employee to conduct some sort of task. Employer has no control over the details of conduct of independent contractor. I have my store, I hire somebody to put in internet infrastructure into my business. So that person is an agent, and they have control over that part of putting in the internet. They don't really, but they're not an employee. Figuring out whether somebody is an employee or an independent contractor can be very important in some fields when things go wrong. This is when there's like something has gone wrong, and you're like, no, that's not an employee, that's an independent contractor. They can't bind me. Does worker engage in distinct occupation, independently established business? Well, you can say every Uber driver is an independent contractor. They operate sort of independently in their own little cell phone business of their car. Is the work done? Well, say a taxi driver might work for a taxi company, and they are not an independent contractor. Is work done under employer supervision, or does specialists without supervision complete the work? Your Uber driver. The other ones, there's no Uber manager looking over them. They decide who to pick up and do all the driving. Does the employer supply the tools? Well, the Uber driver has their own car. It's a big requirement. Taxi company provides the taxi for the taxi driver. What skill is required for the occupation? What is the length of time for which the worker is employed? Is the worker a regular part of the employer's business? And how is worker paid? So there's going to be a totality of facts that they look at to see whether this was an employee or an independent contractor. To give you an idea of why this becomes important, you're hit by an 18-wheel rig. And who are you going to sue? Was the driver an independent contractor or an employee? Because if they're an independent contractor, they probably don't have as much money. So you want to go after the employer. So you have to go through this process to determine whether they were, in fact, an employee or an independent contractor. Simply stating I'm an independent contractor or that person's an independent contractor doesn't mean that they necessarily are. They apply all these factors and look at them. Okay, so some of the principal's duties to the agent: compensation. They have to pay them back. They have to pay them a salary of some sort or a percentage. Reimbursement, indemnification, for any expenses that they incur while doing business for the agent. Cooperation and safe working conditions. The agent also has a duty to principal: loyalty, notification, performance, obedience, and accounting. That they are acting within their agency is what this means, and that they're providing good bookkeeping in any money that they take in for the principal or for any costs that they incur. Loyalty means that you are acting on behalf of the principal and not yourself. Principal's rights and remedies against the agent. Constructive trust. I'm going to pause for a second. Okay, so constructive trust. And let's say the agent enters into an agreement and then keeps the money. Constructive trust means that they have to give them, the principal can go after them and get the money from them in law. Avoidance. Well, that means that if you enter into a contract that you weren't, that I did not give you the authority to do, I can avoid the contract. Indemnification means that I can go after the agent for any harm caused to me by the agent when he was not acting under my authority. The agent's rights, sometimes it can be tort in contract remedies. They might be actually spelled out in the contract. Demand for an accounting. You know, you said 15%, I'm going to demand to see the books to make sure that I got 15%. Specific performance, something that's specified in the contract. Authority of agent and liability of the principal. Okay, express authority. Principal explicitly instructed agent to perform an act. Complete authority. Implied authority. Relationship inferred from actions and conducts of the party. Authority inferred from nature of relationship. You told me to see the manager, which gives the manager implied authority. Apparent authority in estoppel. Third party reasonably believes, based on actions of the principal, that agency relationship exists between the principal and another individual. Contractual liabilities of principal and agent for authorized agent acts. Authorized agent acts within the scope of authority. Classification of principal must be classified as either disclosed, partially disclosed, or undisclosed. That means if I'm the agent, I have to either disclose who my principal was or make it clear that they are undisclosed. In a disclosed principal, the agent is not liable, but the principal is liable. Partially disclosed principal, agent possibly liable, principal still liable. Undisclosed principal, agent is liable, principal is liable. So if I enter into a contract with somebody and my principal doesn't perform, I'm still liable. And under that last and possibly partially disclosed, in the undisclosed principal, I might have to end up paying the damages. Contractual liability of principal and agent for unauthorized agent acts. Okay. An unauthorized act goes beyond the scope of the agent's authority. Now, did the third party believe the agent had authority? If it was a reasonable belief, the agent is liable. They're the ones who have to pay. Pay the damages, but the principal is not liable. Third party believes agent mistaken about his or her authority. I thought, you know, the agent says, hey, I can't enter into something like this. You say, yes, I think you can. Well, nobody's liable. Towards an agency. Okay, the agent commits a tort. The principal can be responsible. First off, if the principal directs the agent to commit the tortious act. Hey, you're my agent, I want you to tweet out these things, even though they're defaming my competitor. Principal fails to provide proper instruments, tools, or adequate instructions. All right, this would be like on the work site. Tools, there's something wrong with a tool, it flies off and hurts somebody. Well, that's the principal's fault for not providing the proper tools. Agent misrepresentation. This is really rare because it involves, if the agent misrepresents himself to a third party, the principal may be tortiously liable for agent's misrepresentation, but it's only if the principal has done something to make it look like the agent did have that authority. Respondent superior. The principal and the employer is liable if the employee wrongfully interests third party. Principal didn't hurt anybody, but they're liable because I was stupid enough to hire a negligent employee. So, Rouse has a delivery and they have the delivery trucks. Well, say they got in an accident and it was because whatever, there was a problem with the vehicle. So that's the principal failing to provide proper instruments, tools, or adequate instructions. Also, respondent superior, where the employee person driving that truck is an employee of mine. It's a little bit different with an independent contractor. Under the doctrine of respondent superior, the individual who hires an independent contractor is not liable for the independent contractor's tortious actions unless the contractor is hired to engage in hazardous activity. So, the pizza delivery guy that uses his own car, chances are that they are an independent contractor. You get in a wreck with them, you cannot sue Pizza Hut for damages. Even if the guy has the Pizza Hut delivery thing and they're delivering pizza, they are an independent contractor. So the principal of Pizza Hut can't sue them. Notice of termination of agency, these are pretty self-explanatory. Actual notice, constructive notice, things that can also terminate an agency relationship for these lapse of time, fulfillment of occurrence. The only thing that doesn't work is agency coupled with an interest. They probably won't terminate. You probably can't terminate that relationship. An agency coupled with an interest is an irrevocable agency. It occurs where the agent has a security interest in the subject matter of the agency. Maybe my agent has a lien against my property. Well, I can't fire them as an agent because they have a lien against my property. Also, various terminations by operation of law, death, insanity, bankruptcy, disloyalty of agent, that definitely terminates. So that's it. Read the chapter carefully, do the SMART book, and take the quiz. And thank you for your time.